Hello viewers, the second lesson of the course is on classification of legal thought. Jurisprudence deals with the nature, structure, purposes and functions of law and legal systems of the world. The province of jurisprudence has been determined and redetermined because the nature of the subject is such that no delineation of its scope can be regarded as final. For example, on torts or contracts, a student may be recommended to read only the standard textbooks with an assurance that whichever book he does read, he will derive much the same idea as to what the subject in doubt. With jurisprudence, it is not so. Books called jurisprudence may widely vary in subject matter and treatment. The reason is that these writings concern thought about law on broadest possible basis rather than expositions of law itself. The core theme of legal theory centers around what the law is or what is its nature and or function. The purpose of legal theory or jurisprudential venture is not to reproduce juristic notions ad verbum, but to provoke or stimulate an intellectual exercise. Socratic discussion and controversy upon the basic theme and essence is propounded with a view to provide justification and explanation for its acceptance or rejection. To have pinpointed discussion on various themes, jurisprudence may be divided into different branches. It is common to separate jurists into various schools. Such a classification is useful insofar as it is confined to an attempt to label in a broad way some of the most significant approaches in jurisprudence. Classification of jurisprudential thought. Attempts have been made to categorize the wide variety of theories of law in jurisprudence. For example, Jerome Hall in his text Readings in Jurisprudence arranged theories of law as follows: natural law, historical jurisprudence, transcendental idealism, utilitarianism, social functionalism, pragmatism. Bodenheimer's jurisprudence arranges legal theories under the following heads: Greek and Roman theory, legal philosophy in the Middle Ages, natural law in the classical era, German transcendental idealism, historical and evolutionary theories, utilitarianism, analytical positivism, sociological jurisprudence, and the revival of natural law. Julius Stone in his text The Province and Function of Law, a Study in Jurisprudence, finds it convenient to organize jurisprudence into three branches: law and justice, law and state, law and society. Early editions of Samen's jurisprudence included an analysis of the contents of jurisprudence. Three types of jurisprudence were enumerated: analytical, historical and ethical. Diaz in his text Jurisprudence discussed legal theory as follows: positivism, British theories, the pure theory, historical and anthropological approaches, economic approach, sociological approaches, modern realism and natural law. Keaton in his Elementary Principles of Jurisprudence suggests the following structure: classifications derived from the standpoint of the content of legal systems, classifications derived from the standpoint of time, classifications based on the standpoint of the number of legal systems involved, classifications based on the standpoint of the areas of knowledge fundamental to an examination of law. the need for classification. Jurists at various times and places have made their approaches to the study of law from different angles. They have defined law, determined its sources and nature, and discussed its purpose and ends. For the sake of clarity and convenience in understanding their viewpoints, these jurists have been divided into different schools based on their approaches to law. But any such division may not be very comprehensive and exact. There are many jurists who may not be falling within the strict bounds of any one school. However, despite the overlapping, the division is helpful. It helps in understanding the evolution of the legal philosophy. Carl Levlin rightly observed, jurisprudence is as big as law and bigger. In fact, there is voluminous literature in jurisprudence. The question, what is law, has been answered by scholars from different disciplines. It was answered by theologians, philosophers, historians, anthropologists, sociologists, economists, political scientists, psychologists, jurists, etc. They examined law and its nature from their subject point of view. There is 25 centuries contribution to legal theory right from 5th century BC to 20th century AD. Therefore, a methodology has been evolved to cover such a voluminous contribution. That method is schooling method. The entire jurisprudential thought has been divided into 4 schools of jurisprudence, namely analytical, historical, philosophical, and sociological schools. This exercise facilitates the students to study the subject without tears. Problems of classification. Classification in relation to legal thought is neither easy nor exact. The following problems have arisen. Arrangement is not classification, although classification is arrangement. The difference being that while arrangement is empirical, classification must be in accordance with some principle. It is not easy to discover an appropriate principle for classification of legal thought. For example, classifications based upon historical context or methodology are rarely satisfactory and tend to be little more than arrangements of legal thinkers and their ideas. Some schools of thought overlap, and a rigid compartmentalization of schools of jurisprudence may perpetuate perceptions of sharp divisions where in reality none exists. Conversely, dissimilar types of jurisprudential speculation may be brought together under one heading, suggesting a unity of thought where none exists. For example, it is not easy to perceive similarities between thoughts of Savigny and Henry Maine beyond a common interest in the significance of a study of the past in jurisprudential thought. It is virtually impossible to place some jurists in any of the standard schools of jurisprudence. Thus, the contemporary American jurist Ronald Dworkin appears to be in a category of his own. How may we categorize Fuller, a self-declared proponent of natural law, who rejects many aspects of thought associated with that doctrine? How does one classify the thought of jurists such as Radbrush, who embraced opposing principles during successive stages in his career? It may be noted that a classification of jurisprudential thought can be little more than an arrangement for the purposes of convenience. Salmon's classification. According to Salmon, jurisprudence may be studied in 3 different ways: legal exposition, legal history, and science of legislation. Legal exposition. The purpose of it is to set forth the contents of an actual legal system as existing at any time, whether past or present. Legal history. The purpose is to determine what has been the historical process and how the law evolved. Science of legislation. The purpose is to set forth the law not as it is or has been, but as it ought to be, which means that this method speculates law in its ideal form. The first of the above methods deals with law as it is. The second deals with law as it was, and the third deals with law as it ought to be. These three methods correspond respectively to the three schools of jurisprudence, namely analytical, historical, and philosophical school. A fourth school of jurisprudence emerged in 20th century, namely sociological school, which subscribes the view that law is as law does. Analytical school. This school is also called Austinian school, as John Austin was one of the chief exponents of the school. As it is popular in England, it is called English school. The purpose of this school is to analyze the principles of law and reduce them to their fundamentals. Professor Gray calls this the method of classification and definition. This method defines and delimits the scope, content, and relationship of legal concepts. As analysis is the chief instrument, this school is called analytical school. But Patton thinks that this title is rather misleading, as it suggests that analysis is the exclusive property of this school, instead of being a method used throughout jurisprudence. Professor Allen prefers to call this school as imperative school. This school has acquired the name imperative school or positive school because it believes that all law is a product of the state, and no rule of action deserves to be called a law if it does not emanate from a sovereign or a state. This school believes that law is an imperative command of the sovereign authority. According to the jurists of analytical school, law must be studied as it exists at any point of time and not with reference to its ancient past. Law must also not to be studied with speculative approach as to its ideal future or form. The law as it is seems to be the motto of this school. Law must be studied as a logical and consistent whole and ought to be treated that way only. The chief advocates of this school are Bentham, Austin, and Salmond. According to Austin, the chief tool of jurisprudence is analysis. The main purpose of analytical jurisprudence is to gain correct and intimate understanding of the working of all legal relations. It takes into account the anatomy of law. It deals with the following matters: an analysis of the conception of civil law, an examination of relations between civil law and other forms of law, an analysis of various constituent ideas of which the complex idea of law is made up, for example, those of state, sovereignty, and of the administration of justice, an account of legal sources from which the law proceeds, an inquiry into the scientific arrangement of law, an analysis of the conception of legal rights and duties, an investigation of the theory of liability, an examination of other legal conceptions. Merits and demerits of analytical school. Analytical school has the greatest merit of having emphasized the importance of defining legal concepts with precision of language and thought. Referring to the contribution of Bentham and Austin, who belong to analytical school, Henry Maine, himself a proponent of historical school, observes that the world is indebted for the only existing attempt to construct a system of jurisprudence by strict scientific process and to found it not a priori assumption, but on the observation, comparison and analysis of the various legal conceptions. The method of analysis is good, as Austin himself said, for the purpose of clearing the head. This school facilitates and promotes clarity of thinking and, as Professor Gray points out, intellectual honesty in matters of study of jurisprudence. The analytical school suffers from the drawback of dogmatism or too much adherence to technicalities of language and concepts. It leads to barren legalism. As Keaton points out, analytical method is a necessary method. No work of lasting value in jurisprudence can be undertaken without recourse to it. Analysis of legal concepts, however, is not an end in itself. It is merely a stage along the road. Jurisprudence is not an abstract study. It functions in societies made up of human beings. As Patton pointed out, it is not always possible to separate law from ideal elements. Consequently, it is neither possible nor desirable to segregate completely the law as it is from the law as it ought to be. Law does not exist as a perfectly proportionate body of rules deduced from a few legal principles. Ethical, philosophical, theological, metaphysical, or the law of nature school. Salmond says that this school deals with the law from the point of view of its ethical significance and adequacy. He says that this school concerns itself with the purpose for which law exists and the method and manner in which that purpose is fulfilled. The law is a means to an end and not an end in itself. Patton observes, this school asks what should be the ideal end of law? What should guide us in developing the law? The ideal end of law is justice. In view of the fact that ethical school studies law with reference to its ethical purpose, Salmond observes that philosophical school is the meeting point and common ground of moral and legal philosophy of ethics and jurisprudence. Law is studied with reference to its ethical significance and adequacy. Ethical jurisprudence is confined to the theory of justice in relation to law. Its sphere is to study what law ought to be. The following points are noteworthy in the study of ethical jurisprudence. The study of conception of justice, the study of the relation between law and justice, the study of how justice is to be maintained, the study of ethical significance of legal conceptions. St. Thomas Aquinas, Grotius, Kant, Hegel, Stamler and Fuller are some of the exponents of this school. The philosophical school concerns itself chiefly with the relation of law to certain ideals which law is meant to achieve. It investigates the purpose of law and the measure and the manner in which that purpose is fulfilled. The philosophical jurists regard law neither as the arbitrary command of a ruler nor as the creation of historical necessity. According to them, law is the product of human reason, and its purpose is to elevate and ennoble human personality. Basic tenets of this school are: law is related to justice, reason, ethics, and human nature. Rules of human conduct emanate from a supreme authority and are binding on all men everywhere. Natural law is opposed to written law. Natural law demands equality of all men. Rules of law can be studied on the basis of a priori method, that is, to accept a thing without any inquiry or observation. The jurists of this school consider law and morality as inseparable phenomena. This school is meeting point and common ground for both ethics and jurisprudence. According to Salmon, the English jurists are mostly analytical, while continental jurists are inclined to ethical outlook. This distinction is found even in their languages. In English language, the words law and justice denote two distinct aspects. But in continental languages, one word covers both the concepts. Jus in Latin, ricet in German, droit in French, diritto in Italian mean both law and justice. Since men think in terms of words in their languages, the continental jurist cannot think of justice apart from law. Whenever he thinks of jus, ricet, droit or diritto, he comprehends both law and justice together. To him, law is justice and justice is law. They cannot be separate. But the English jurist always thinks of law and justice as two independent concepts. This difference in language is said to have led the difference in thoughts as well. Historical school. Savigny, Henry Maine, Carter and Vinogradov were the exponents of historical school. The study of law as it was has been the motto of this school. Historical school was the pioneer of the study of law in society. The basic tenets of this school are: law is an outcome of social necessity, law is found in every society, where there is society there is law, law has its roots in the historical past, law is an evolutionary phenomenon, custom is the important source of law. Sociological school. The Greek philosopher Aristotle remarked long ago that man is a social animal. The science which treats man as social and spiritual being and study his activities and operations as such may be designated as social science. The social scientist has to investigate what means should be adopted to answer certain social problems and prescribe suitable rules of human conduct. Rules of human conduct enforced by political authority or laws. Jurisprudence was the first of social sciences to be born, said Virgil. Jurisprudence as a social science addresses itself to those who study law as a system of knowledge. It treats of the activity of man in society from the point of view of its legal significance. The sociological school considers law as a social phenomenon and examines law in relation to society. It takes a functional view of law. Paton calls it as functional school. Hearing, Duguay, Ehrlich and Roscoe Pound were the exponents of this school. Following are the basic tenets of or characteristics of this school. Sociological jurists regard the working of law rather than its structure. Sociological jurists regard law as a social institution. Sociological jurists study law in action rather than law in books. According to this school, law has to serve social purpose. According to this school, law has to satisfy needs of the people. The realist approach to law is part of the sociological approach. Paton calls it as left wing of sociological school. There are two kinds of realism, American and Scandinavian realism. Oliver Wendell Holmes, Gray, Cardozo, Llewellyn and Jerome Frank were exponents of American realism. Hagerstrom, Lundstedt, Ole Vikrona and Alf Ross were exponents of Scandinavian realism. The different schools of jurisprudence discussed above only emphasize and highlight different facts of the whole body of legal doctrine. Each one of the schools is valid so far as it goes, and an intelligent student of jurisprudence would do well to adopt a sort of eclectic and synthetic approach in this regard. Paton pointed out that these schools are complementary rather than opposed. The dogmatic insistence of certain writers that there is one road to truth has tended to obscure this fact. Salmond also emphasizes the same point when he says that these schools are so involved with each other that the isolated treatment of any of them is necessarily inadequate. The rationale of schooling method. The question arises whether it is desirable or necessary to dissect jurisprudence into different schools in the interests of clarity and better understanding of the subject. It must be considered that the said classification offers two advantages. It permits pinpointed reference, discussion and evaluation of varying views and ideals of at least important jurists who are accommodated within the pigeonhole of school. Cohen says, the house of jurisprudence has many mansions, wherein all different approaches find their respective place. Second, classification of jurisprudence into schools provides an index of the direction of the dominant theme of thesis, be it religious, secular, scientific or sociological, which found support and impetus from thinkers and philosophers in each age. However, there are advocates of the idea of deschooling, and equally there are advocates who are for its retention. The rationale of dividing jurisprudence into different schools is merely pedagogical to familiarize the students with broad dominant legal thoughts in a coordinated and evaluative manner. The methodology of labeling or affixing a brand to each thought system is to sensitize and provoke its ultimate ideals. It is by no means intended to close curtains on the thoughts and philosophies of earlier thinkers. Hence, the ambivalence to categorize and systemize legal theory into schools and of drawing lines between landmarks in the attitude of different jurists is solely due to the consideration of expediency, methodology and uniformity. As such, all the schools of jurisprudence are concerned with nature of law and its purpose. Yet their methods, approaches and outlook vary. However, all these approaches remain faithful to general principles of law. Therefore, it would be apt to conclude that the house of jurisprudence has many mansions which are distinct but not separate. The nature, function and purposes of the said house of jurisprudence are always in a state of flux or change to suit or accommodate the varying needs of time and place. All legal thinkers who contribute to jurisprudence find a respectable place in the mansion of jurisprudence. All of them contribute towards better understanding of jurisprudence in relation to law and society. Thus, jurisprudence has become a museum of intellectual ideas. An attempt has been made in this lesson to explain the importance of classification of legal thought into various schools and the rationale of such classification, and also the salient features of the standard schools of jurisprudence. Thank you.